Those are the scenes from the Constitutional Court earlier on discussing the validity of the secret ballot, and various opposition parties and their council making presentations as to whether the Speaker of Parliament has the right to make a decision or has the discretion to implement a ballot or secret ballot for that matter. Yeah, it's been a marathon of it. A lot of, I guess, crash course into the Constitution itself, a reference to Section 102, subsection 2, the Section 84, 45, etc. But we'll go through it, unpack it for you in bite sizes here with our panelists in studio. Good evening.
Top of the evening to you, South Africa, and indeed we are starting to learn a little bit more about our Constitution. An interesting thing, Cindy, I think what is most important is to hear the herds of argument that have been put forward to the judge and his panelists. I think what's important for me that's come out is to see how elaborative our Constitution is, and listening to the both sides, obviously trying to find out whose discretion, who's got the powers, how do you do the separation of powers? But most importantly, ultimately, can we have a secret ballot in the case of the parliamentary? So I think that, for me, has been the burning question. I thought maybe I'll have an answer before they actually come to an end. I didn't think that we'll be here after 10 hours.
Absolutely, a marathon, as we mentioned. We're joined in studio live by Tsepo Khadima and Sfiso Mahlangwa, resident political analyst. Tsepo, good evening to you, gentlemen. Thanks for joining us. And you at home are most welcome to participate as we unpack this thing that everybody has lauded, or most have lauded, as being a constitution that is second to none, and yet it's still disputed as to the separation of powers. Who makes the call when it comes to the secret ballot, as it were?
Very interesting day indeed. And indeed, yeah, I think we learn every day. But I think the question that I had hoped that by now would have been answered is that why was there 10 hours of court time spent in arguments, and specifically when the authority upon which such arguments would have been advanced, didn't seem to be in any shape or form agreeing with the arguments that were being advanced. I think earlier in the day with Advocate Mpofu, we saw that he used a lot of case law, comparative case law. The only value of comparative case law is persuasion, or is persuasive, and doesn't really have the authority. The authority is the Constitution. The Constitution of the country, Section 2, says that the Supremacy Clause, as it's called, the Constitution is the supreme law of the land, and any law or conduct inconsistent is invalid. So then, of course, we deal with the fundamental constitutional provision that is of separation of powers. And separation of powers clearly, specifically dictates as to who can do what in terms of the three branches of the state. And effectively, the whole case, when you narrow it down, what the applicants were asking the court to do, the court cannot do with the best will in the world. And I think that the SC for the National Assembly, Advocate Moerani, when he quoted specifically what the Chief Justice had said earlier in another court, that sealed it, that in a case of law, it is impossible for the Constitutional Court to misdirect itself, overreach, by determining what rule the National Assembly can make, or it is impossible for the court, and the Constitutional Court for that matter, to make rules. The court only interprets the applicability of the law, doesn't make the law. And the remedy for all of this would have been that if the opposition parties had indeed, as Advocate Semenya was saying, had gone and stipulated really the risk factors that they perceive and convince the other members of the National Assembly to be able to then vote to allow the secret ballot, or to then cure it once and for all by avoiding any ambiguity by amending that Section 102, as the legislature is the only one that's empowered to amend the Constitution to specifically say,
so, I just want to
shall be by secret ballot.
Let's take it in bite sizes for those who've been sort of dipping in and out of the discussions in court. It does get a bit technical, even if you have the Constitution in front of you and you read it religiously. But the way it's applied is based on what the Speaker ought to do. Was she obligated to just, based on the National Assembly rules, to decide on a secret ballot, especially in the protection of those that fear reprisal or victimization?
Nobody has advanced any argument to support obligation. There is absolutely no obligation. It cannot be read into that section 102. And I think it will be unforgivable for the Constitutional Court justices to actually misdirect themselves and overreach to the extent of amending Section 102. Section 102 is as is. What we learn from this is that the founding fathers of this constitutional democracy were not psychic enough when they were drafting the Constitution to foresee a situation such as the one that we have, and therefore it's left to those that are incumbent today in terms of members of the National Assembly to then do that which the Constitution permits them to do, to make an amendment, again, in line with that which is amendable in terms of our constitutional scheme. And of course, this Section 102 certainly would be amendable. They just need to have the enough number. So the whole argument is political, and it can only be settled politically in the National Assembly.
Yeah, I think what was quite interesting, and maybe this is why I bring in Sfiso here, is that there seemed to be a belief, and the arguments that were built around this particular one is that the conscience of the members of parliament came into effect. They were talking about party lines and doing what is the party rules in terms of parliament versus you being an MP. And I think there was a point where they actually separated the two, saying that, yes, you are not put there by parliament, you are put there by the people, and therefore when you respond, you must respond not in party lines, but with regards to your conscience. Do you think that there are split consciences within the arguments that have been made in Parliament? But most importantly, do you think that perhaps it is alerting the fact that the African National Congress in itself has not made representation in opposition of what the opposition is currently putting up front in front of the Constitutional Court?
Well, I think, Clive, there are two words that have dominated the fourth chapter of today's sitting, and that was the word conscious and discretion.
Yeah.
I think they really
and
tried
backbone.
to find out
Backbone.
what is really meant by conscience.
Yeah.
And then they had to really debate, let's talk about backbone. The party conscience is safe. When I go to exercise my constitutional right and I vote for a party, I act as an individual. But the MPs who are in parliament are there because the population of South Africa has mandated them to represent them. So they are there on a party call. They are there on a party line.
So you didn't get there, sorry to interrupt you, to get there by your conscience.
You didn't get there by your
own
conscience.
volition.
You got there because
deployed.
the electorate voted for a party, and that party put you in parliament.
Right.
So if you have a particular voice, you execute that voice as a single electorate member when I go to the polls and I vote whoever I want. And I think that was a definition that they really exhausted today. But on the part of discretion, it was really interesting today to learn that it is back to Ms. Baleka Mbete, who then has to decide. But Mr. Mpofu was really aggravating the fact that who decides the merits of what she should credit and discredit? Surely the court should know what to do, because the reason one goes to the court is because there is a challenge in society. And here they are citing that there is a problem in the South African National Assembly. And the only reason that there is a court sitting is to try and amend or try and assist the challenge that is there. But the secondary argument was that you are now exercising party lines by coming here. If you really believe that the National Assembly Speaker has got the right and the mandate to decide, why don't you allow her to make that conclusive decision, and then we don't need to come here? The first part of this conversation, I think this debate, was rattled by whether the UDM had the right to go to the High Court, whether they had the amicable cause why do you need to be here? Why do you see it fit to engage me? And I think Mogoeng was trying to clear himself today to say, why do you bring me into
and
a
what do you
political
expect of
space?
me when we
what
have
do
to
you
have
expect of me? Because I think you know your rules, you've thoroughly read the rules of parliament, and if you're going to come and say you are afraid of being intimidated, that's why you want a secret vote. But surely you know Section 41 of your National Assembly Code. You know of the rights and privileges. Surely if you cannot be protected in the National Assembly, then you'll go to the SAPS. You can't come here and say, well, if in the case that I am intimidated. When you are intimidated, you know what to do. But why do you want me to engage on a political space, on a space that I may not be comfortable to echo in, and a space where I might not be suited to speak because there is a National Assembly Speaker? So I really felt that the Chief Justice was trying to exercise the separation of powers. But at the end of the day, it's a political mandate. The EFF, the UDM is doing what they have to do. And, you know, an analysis has got to come.
Yeah.
A judgment has got to come.
Maybe also the preamble is the fact that we've heard about the number crunching, that in order for the vote of no confidence to pass, there's already a weak link, if you will, within the ANC MPs.
Yeah, let me just echo this, Cindy. Like, the African National Congress in Parliament has got 249 seats, 249. The Democratic Alliance has got 89. The EFF has got 25 seats. The IFP has got 10. The National Freedom Party has got 6. The Freedom Front Plus 4. The UDM 4. The rest have got between 3 and 1 seats in Parliament. So they've done their maths. The opposition parties have done their maths to say there's no way that we are going to win on an open vote. Because if the vote has got to be open, we are already out of numbers. Even if half of the people in Parliament voted against the ANC, or half of ANC MPs, it would make 125, which is still higher than the DA. So I think the ANC wants to know which people have either gotten the brown envelope or which are lying. There's no intimidation there, and to put it on record, because the records must show. Even the EFF, when they were in when they were doing the debates for the coalition governments with the Democratic Alliance, they had to put on record which members of the EFF have voted for the EFF and not with the ANC, because they wanted to vote on party conscience. So I think these parties have done their maths. You can't win in numbers because the ANC is still an override majority. So allow them to vote in secret. I think that's what they want. Try and convince them by any measure of psychology, by attempts of, you know, of a political nature. Try and be meticulous or even malicious if you can. Try and bring them on your side. Cheat and lie if you can, but
isn't it an indecent proposal?
And it's really an indecent proposal, because I think that's what the ANC was saying, to say, if you want people to vote in secret, what you are encouraging is that people will be paid, people will get phone calls to say, you'll get R1 million in your account tomorrow, or we'll promise you a position in future. That exercises horse trading.
Yeah, but that's exactly what Tsepo was saying.
Vote openly, so that they know that you know, their vote is open.
That's inducive, isn't it?
Yes, of course, it's inducement.
Yeah, it's inducement.
I mean, look, apart from what I think Musi Maimani, Van Dam, as well as Julius Malema already have confessed publicly that they've got a certain number of MPs who you can only read that they have been induced to vote with opposition. But also there is, again, that very same requirement that these parties have. We must not forget that, by the way, that the Democratic Alliance, its own constitution, in fact, affords a member of the Democratic Alliance who votes against the party line no due process. That member is suspended, or rather, is actually dismissed.
Without stopping you, we've seen this because now there's been a tweet that there's a member who's tweeted, and she's going for disciplinary.
Exactly. So what you are seeing there is that...
But her boss has not been disciplined.
But what you are seeing there is effectively hypocrisy of the highest order. Because at the same instance, we saw with the local government elections, we saw one Floyd Shivambu was towering over the new councillors for the EFF, in Johannesburg to ensure that they voted with the Democratic Alliance to avoid what happened in Rustenburg. So, by their own admission, they are demanding and requiring their own members to vote with them and then induce, financially so, and therefore it's dishonest conduct and corrupt, to vote with them. And those 50 to 70 members that they keep talking about, I think WikiLeaks will soon be telling us who they are.
Is it conscience then?
It's not, no, it's not conscience. It's in fact dishonesty in the truest form. But what they are asking the court to do, the court cannot do, because if the court was to be seduced into assuming the status of being a superior branch of the state, and the Constitutional Court and the judiciary specifically, to be a superior branch of the state, that will plunge us into a constitutional crisis. And not only will it plunge us into a constitutional crisis, if the justices misdirect themselves, overreach, those justices will find themselves being subject to impeachment proceedings because they would have seen to be themselves misunderstanding the fundamental principle in our Constitution of the separation of powers, and there can be no interpretation other than what is expressed in the Constitution, specifically on this section 102. There can't be any reading into it, and if there is to be any reading into it, the closing remarks of Advocate Mpofu, that speech is the speech that his party was supposed to have been making in Parliament to convince the National Assembly members to actually vote to either make the rule for secret ballot or to amend the Constitution to specify section 102 that it shall be under, it shall be by secret ballot and no other way. But right now, as it stands, absolutely, I cannot see how this Constitutional Court will hold course to agree with the applicants, because they have not been able to make a substantive case in law on why they are putting the court in this invidious position of having to overreach.
Yeah, but maybe, sorry, Clive, in the sense of a perceived or real threat to one's livelihood as an MP if you vote against your own party, against its leader that had deployed you there in the first place. So if the protection is required so that the point can be proven that we've been sold, to say those, I'll call them conflicted MPs, ANC MPs, would have voted differently had it been under a different environment where they feel protected.
They don't have a birthright to vote against the president, by the way. Their right is derived from them having been nominees of a party. Our Constitution, very specifically at the beginning, recognizes a multi-party democracy, that ours is a multi-party democracy. There is no member of parliament who's there on their own steam. They are there as a direct result of having been nominated by the party that they belong to. And therefore, that being the case, and with our Constitution recognizing the multi-party democracy, it cannot hold that on this matter, there can be an MP who says, well, in this case, I will act on my own accord. If they put the courage of their convictions, would be then to resign as being a member of that party. Well, we had floor crossing in years gone by, and that has since been disallowed. So, in fact, they can't even go and trade their vote, because that, again, was the fundamental of it was this. You were here. You earned your seat as a member of parliament as a direct result of your party having garnered a certain number of votes in an election. How can you, therefore, midstream, go and trade that? The electorate, if they had a specific express understanding that they are giving you that mandate to then go and trade it to the highest bidder, as now
so
is the
it's not
case,
a share certificate that you can bequeath and maybe
yes.
you can leave for your descendants.
According to Rule 103, Sub-Rule 6,
let me reference them.
The member and the vote must be printed in the minutes of the proceeding, which means whoever votes, and as it has been done before, in an open vote, the individual and their vote would go on the minutes book to who you voted for. So trying to now manipulate the process and taking it to the highest court in the land is because the minutes will always deem who voted how, because you represent the masses. And so if an MP sits in that chair, they don't represent themselves and that house. They represent the 22,000 people that constitute to one seat in parliament. So if one person is seated in parliament, they are a representation of a demographic of this country. And so, you had to put your name and what you voted for, and it comes up in the minutes of parliament. And so they're trying to turn that around, and so that the minute book would disappear, they'd all vote in secret, and no one would ever know, and unanimously one would have to read the votes. But it's always been done in ages before, that you put your name and who you voted for, because those minutes are read at party lines.
Let's have a look at...
would have to go back and reassemble to say, this is how we voted, how do we retract from a secondary vote, why we voted this way. The chief whips would assemble that notion. If people then vote in private, it's a problem, because the chief whips cannot collaborate how the voting went.
But the Constitution does not disallow that. And
absolutely.
So what I'm trying to say is, what the court was listening to today was the fact that, in actual fact, somebody must take responsibility. Obviously, in this case, the National Assembly and the Speaker of Parliament can make they have a discretion to do so. My question to you guys is that, how do we then protect, and this is what the argument from the opposition is, they're talking about intimidation, they're talking about being lured, they're talking about making a result, and they're making it as comparison with the right to vote, which is also inscribed in our constitution with regards to when we vote for a particular party, that we've got a secret ballot box that all these elections or these votes are put into, so that nobody can know. And it was defined to some extent to say, listen, you don't want people to be intimidated to vote for a particular party. Is that scenario then, can that not be tested in the same way when you refer to the National Assembly? Say, listen, because my conscience is with my party, but I know for a fact that maybe I've lost confidence in the president, then I'd rather, for the sake of my independence, I want to vote with no confidence, in secret, that the president must be.
Well, yeah, if that was to hold, if that was to hold that they could vote in secret, the National Assembly is well within their constitutional conscripts to be able to make laws, rules that allow them to vote by secret ballot. They can adopt a rule to vote by secret ballot. But you have to then persuade in the political realm that it is important to vote by secret ballot. What we saw today was that there was an allegation that members of the African National Congress, members of Parliament of the African National Congress specifically, are subject to a risk that is not quantified, that is not clearly been identified, that cannot be tested in a open court, as our constitution so advocates transparency, openness. So that risk that they are suggesting, they have not been able to adduce substantive facts on why they believe that is a clear and present danger. So on that basis, I cannot see how the court can actually accept such a proposition and such an allegation which is not supported by any fact whatsoever. On the other hand, it's the nature of the game. Those that believe that the Constitution is inadequate, they need to simply hold course, push for an amendment of the Constitution, or have an adoption of the rule, because the Constitution, as it was correctly pointed out, does not preclude voting by secret ballot, but at the same time does not specify voting by secret ballots. That is left to the National Assembly. And there's absolutely nothing that the Constitutional Court can do to direct the National Assembly to make a specific rule. If they do so, I can assure you there will be a constitutional crisis, and those justices will themselves be subject to impeachment proceedings.
Allow me to quote the Constitution, and this is section 102, subsection 2. And the operative word there, it says, if the National Assembly by a vote supported by a majority of its members passes a motion of no confidence, then it gives you the ramifications thereof. The president, his cabinet, and MPs must resign. But it says by a vote. So if there was a need to specify that, there is room to maneuver and have a secret ballot, surely the policymakers would have found it or deemed it fit to include it?
The National Assembly can decide how.
To the National Assembly. That's why there is a National Assembly Speaker to facilitate the proceedings. The National Assembly Speaker becomes the principal or the program director, the head of proceedings in Parliament. So what these talks, these debates today, these arguments are trying to remove the right of the Speaker to exercise her discretion. If in fact the Speaker has no discretion and has to follow the courts, then why does South Africa have to vote every 5 years? Because the people will vote. After we vote, a month later, political parties in Parliament might oust the president. So it takes the right from the voter. It removes the power from the electorate. And the word democracy means the people shall govern. But if political parties get there and there's horse trading, then that removes the grace and the power to orchestrate democracy by the people of South Africa. The court is the final arbitrator. And I think that word was misrepresented today because it's not the final judge, it's not the final dictator. The arbitrator means the court will have to now take all the facts, look at the pretext, and then apply the law, which means now they'll have to contextualize the law of what it means with the rights of the Speaker to hold this ceremony.
That's so we'll come back to you straight away. We just want to talk to Calvin Ongmu, one of our reporters who is at the Constitutional Court, just outside there with Mr. Niran Singh of the IFP. Calvin, top of the evening to you.
Thank you so much, Clive. I don't know if I can say halala to you after 14 hours of long court proceedings.
Absolutely.
But without keeping you all waiting and without keeping our leadership here waiting, it's pretty chilly here. We go direct to him for the reactions. Thank you so much for speaking to us, Mr. Singh. How did you see the day's proceedings?
Well, at lunchtime, during the recess, I said to Ian and 7 viewers that I was quietly confident. Now I'm even more confident that the court's going to rule in our favor in saying that the Speaker had the right to allow a secret ballot in a motion of no confidence. And we're hoping that after we get this judgment, well, we're still crossing our fingers because it's never over till the fat lady sings. But once the judgment comes through, we're hoping that we can go through the motion of no confidence and allow people to vote with a conscience in Parliament.
The whole day we heard judges spending a lot of time talking about Section 102. What is your assessment of that take on the discretionary powers of the Speaker?
Well, Section 102 provides for a secret ballot when you're electing. And we have always been arguing as the IFP way back since 2012 with Dr. Mario Ambrosini, our Chief Whip for Merwe, Prince Buthelezi himself in parliamentary speeches, and I as the current Chief Whip. We've been arguing that it just makes sense that if you vote somebody in by secret ballot, you should be also allowed to vote that person out by secret ballot, especially when it impacts on the future of the country and on the executive. We have to hold the executive accountable as members of Parliament, and we need to hold them accountable through the vote. And now with the secret vote, hopefully we'll be able to do that.
But don't you think, as an opposition party leader, that the secret ballot is going to encourage a lot of bribery, buying, selling of votes? Don't you think that?
Well, in the IFP circles, there's never been anything like buying and selling of votes. But we hope that there is robust engagement with particularly members of the ruling party, because we in the opposition are going to stand firm on this one. We know which way we're going to vote. And we hope that members of the ruling party, if the judgment goes our way, will now have the opportunity to vote in terms of what they swore as to the allegiance to the Constitution to when they were sworn in, and that they will do the right thing in the interest of the country, the future of the country, the economy of the country, the good service delivery in the country, etc.
But let's just be balanced and say, what if the judgment does not work in the opposition party's favor? What happens then?
Well, we'll live to fight for another day. I mean, that's what politics is all about. You win some, you lose some. And like I say, I'm even more confident now, but it's never over till the fat lady sings. Let's wait for the judgment, but we are not going to stop or hold back on still putting pressure on this government and on this executive and on the president to account for service delivery in our country. If you see the kind of service delivery protests that are taking place all over the country, it doesn't augur well for the future of our country and for what investors from outside the country think about South Africa at this moment in time.
Thank you so much for speaking to us, Mr. Singh. That was the IFP leadership, Narendra Singh, speaking to us. We will try and get more reactions as the opposition party leaders are addressing crowd outside the premises of a constitutional court. Back to you.
So, Calden, if you just maybe hold on a little bit there, do you expect anything to continue late into the evening or a decision to be made by this evening?
No, judgment has been reserved, Clive, and that is all we were told. And I think everybody were just happy that at least, the submissions were made by all parties, the opposition parties, President Jacob Zuma's legal representatives, as well as Speaker's representatives, Chief Justice, as well as the Aji Justice has said that they need time to deliberate on this matter, as it is a high-profile matter that we were hearing today. So judgment will be delivered next time.
All right, so we don't have specifics as yet, but find yourself in higher ground, warm at least, in somewhere in a huddle, and we'll touch base with you. Thank you so much. That's Calden Ogmo speaking to IFP leader, then Narendra Singh. Gentlemen, just again looking at, and Chief Justice made it a point to highlight what the ramifications are of having a democratically elected president, whether we like him or not, being removed by something that is a discretion of the Speaker, that is not outlined in so many words in the Constitution, that it could destabilize the country, even further junk. Is this an indication that, the court obviously has to apply its mind beyond the sideshows and the voices of dissent?
Look, the effect of if the motion of no confidence was to carry, the effect of it is that it collapses one branch of the state, which is the executive. So it means the president, the deputy president, and cabinet members, which is ministers and deputy ministers. Everybody, lock, stock, and barrel, hele moet weg. What is the consequence of having the entire branch of the state collapsing? That is a serious business. That is not what the opposition parties are actually arguing there, I think, by underestimating the consequences of collapsing the entire branch of the state, which is the executive. But at the same time, the way to do it, and as provided for in the Constitution, will be for the National Assembly then to determine, as so empowered by the Constitution, the manner in which it goes about collapsing the one branch of the state, as to how it will cease to exist and get reconstituted in whatever form that they would then vote thereafter. So therefore, can the National Assembly make rules to vote by secret ballot? The answer is categoric yes. Can the court order them to make such a rule, specifying that they vote by secret ballot or vote openly? The answer is a categoric no. The court has got absolutely no power, no jurisdiction for such. But also, on the other hand, the other point that has not been argued on this inducement thing, which is effectively the dishonesty. We see the oldest constitutional democracy in the world is the United States. There was a number that came up last year, was published by Fortune magazine, that the big corporates in the United States of America spent well over $400 million a year, $400 million US, on bribing congressmen and senators. But their law allows them to do that. And as a result, you end up with a situation whereby that democracy and the Constitution, it therefore gets impeded. I think earlier off air we were talking about gun ownership, for example, that it is impossible to actually repeal gun ownership notwithstanding the origins of legalizing or constitutionalizing gun ownership. Because what we have a situation whereby today the gun manufacturing industry or the armaments industry, they will put as much money as possible to ensure that that particular provision of the Constitution is never amended to limit or prohibit gun ownership by ordinary citizens. Now, in South Africa, you might end up with a situation whereby there is this inducement. We must not forget that there is a great deal of interest in this country by outside foreign powers who have put in limitless resources to actually subvert our constitutional scheme.
Yeah, we're going to have to leave it there, but very briefly, as we saw, for the benefit of our viewers, the Constitution, our democracy is still intact. When this process has been properly deliberated on by the respectful judges and Chief Justice, it would all be in the interest of South Africa, not necessarily in the favor of a political party based on the outcome.
It would be in the favor of South Africa concerning that, considering that members of parliament would vote with in line with what the masses have demanded them to. If members of parliament remember who put them in parliament and the people that they represent for that matter, and not fight factionalist agendas within themselves, I think then the people will win. However, if the court in this case allows the vote of no confidence in secret, it has crushed the executive and assumed that the judiciary is higher than the legislature. And that's going to be a problem in this democracy moving forward.
Constitutional crisis if they do order.
It's going to be a crisis.
All right, we're going to watch this one very closely. Gentlemen, as always, thank you so much for joining us. And to my colleague, Clive Ramatibela-Smith, it's been a long day.
It has been a long day.
Although it appears like we haven't done much, we've actually been here throughout. So you at home, thanks so much for joining us. Be abundantly blessed. Up next, Len Moleko with the beautiful game. We'll see you again tomorrow.